The last thing on the outline is identify legal options to families with major special needs. Let me just talk about a few of those. Two things that are forgotten. And I will say that we don't use them very much, but we do threaten them from time to time, are dependency proceedings and civil commitment. For example, civil commitment. In the situation that I was just talking about, the older families, and usually the person at home is mentally retarded. I mean, sometimes they have mental health issues, but more likely than not, they're mentally retarded. There is a civil commitment process for people with mental retardation. I mean, it's like something no one is aware of, but it's in the law, and if you are mentally retarded and need residential services, the civil commitment process is available. And I will say that, again, I have never gone to a civil commitment hearing, but for mental retardation. But I will tell you that we have prepared a few of those petitions and sent it to county agencies. And when that happens, referrals go out for placement. Because now, frankly, that name became red on the list. When you send the commitment petition and say, look, we're going to go before a judge and ask the judge to commit this person. And we have a facility in mind. We've gotten them accepted at the facility. What are you going to do about it? And again, it is something that nobody talks about, I guess because, one, people aren't thinking about it, and two, the various agencies don't have any incentive to tell people about it, and I understand that. They're dealing with their own budget crises. But if the family's in a crisis, not to the point their name is in red, but a crisis that they just can't do it much longer, what the civil commitment petition does is it takes out of the hands of administrators the total discretion they normally enjoy. They normally enjoy, well, we decide whose name is what color up there, and we decide where they go. But absolutely the law recognizes civil commitment proceedings for people with mental retardation. Now, it's not risk-free. The court has discretion where to put that person. It could be at a state center where they don't belong. But ironically, county agencies in the Department of Public Welfare, the same agencies that may not have been, again, for valid budgetary reasons, terribly aggressive in finding a placement, they don't want this person at a state center either because it's not appropriate. They are generally at or very near capacity, and they know they're going to have to move that person. So it is at least an option. You know, it's not the first line, it's not the second line, but it's in the quiver of arrows that families need to consider for anyone who is in need of services, and whether it's mental health, mental retardation, at whatever age, child or adult. If you meet the commitment standards, it should at least be thought about. Dependency proceedings. You know, we have families that just don't know what to do. The child may be out of control. Their behavior can't be controlled, but they may not be committing crimes. They may just be at home, screaming, threatening, punching holes in the walls, but not the kind of stuff where police are going to take them and keep them. They're just wreaking havoc in the family. A dependency proceeding is something at least to consider. Because if the child is incorrigible, that's where dependency originally came from, was for children who were either without parental support or with parental support but couldn't be controlled. And we don't tend to think of that anymore for kids. But for some kids, it may be the option to get them into a residential placement by having a judge order them into a placement. Because getting residential placements from school districts is hard. It is something they have to provide where the child requires it. But school districts do not offer it up unless there is no choice or the parents, frankly, hire counsel in most cases. So, but it is another avenue to at least talk about with families. And obviously guardianship for individuals over 18 to declare them incapacitated and have the decision-making put in the hands of someone else. And obviously, if the child is 21 or under, hasn't received the diploma, special ed due process to pursue a more appropriate program for the child, which can include a residential placement. Really any kind of placement that the child requires. The special ed law changed in 2005, not only about transition planning, but what kind of services have to be provided. Now, services instruction has to be based upon peer-reviewed research to the extent practicable, which is very significant in that, just as I told you about the child with a 100 IQ who was reading at a 4th grade level, these research-based programs in reading, writing, math, behavior are proven to work. And if they're out there, their districts are required to use them. And they're required to implement them consistent with the research. They don't always do it voluntarily. Again, in fairness, they have budget issues, but if the child is behind and a research-based program can assist them, a district is required to provide it. And in many cases, the research is very strong. Children with autism, the LOVAS, Applied Behavioral Analysis method, very powerful research to suggest it's a way of managing their behavior and allowing them to make meaningful progress in a variety of social and emotional ways. So there's a lot out there, a lot that can be helpful. And it's our job to try to help people find it. Thank you.